Good morning. We'd like to call the December 4th, 2019, 10 a.m. post-council meeting to order.
Morning, Mr. Chairman, members of the council, Mr. Vice Chairman. First case is Deputy Sean Bell. The sustained allegation against Sean Bell, who is currently Utah County Deputy Sheriff, is a BCI violation. That's a Category E offense. The range is a letter of caution to 1.5 years. The baseline is 6 months, and Post is recommending a letter of caution. There are no aggravators, and the mitigator in this case is that he did not disseminate the information beyond himself. He has 28 years of service with the Utah County Sheriff's Office. On September 9th, 2018, Sean Bell was investigated for a BCI violation. The investigation disclosed that on June 12, 2018, Bell accessed protected information to conduct a records check on a vehicle without a law enforcement purpose. The internal investigation determined Bell violated department policy, and he did not have a valid law enforcement purpose to access protected records to conduct a records check on the Wildlife Service vehicle. During Garrity interviews with his agency and Post, Bell did not recall accessing protected information on the vehicle and said he didn't know why he would have conducted a records check on the vehicle. On October 16, 2019, a hearing was held before an administrative law judge. The ALJ subsequently issued findings of fact and conclusions of law stating that Bell violated Utah Code 536211 as outlined in the notes in this case. I see that that Deputy Bell and his attorney are present. Would you like to?
My name is Rich Willey. I'm an attorney for Deputy Bell. I'd like to give my client just a couple minutes to address the council here, just give his side of the story, and then I'll take a couple minutes right after him to speak.
Thank you.
Good morning, ladies and gentlemen. I stand before you very humble. Like she said, I've had 28 years in law enforcement. I still wake up every morning, and I'm just as eager to do my job as I was when I first started. There's nothing more I enjoy in my life than going out in the community and protecting and serving. On this date in question, I did come in contact with a woman that I knew prior who worked with injured animals. I had seen her vehicle, and I did see a phone number on the back of her car, and I'd contacted her on that number and asked her if she would pull over and speak with me. And she did, and we had a consensual conversation. It was probably about 10, 15 minutes in duration. She had expressed some concerns that her husband had recently passed away. I had complained to her about another wildlife individual who I'd had a negative interaction with, which I realized at the time was not the best time to be having that conversation. Unbeknownst to me, I found out later that those two individuals were friends, and they got together and went in and made a formal complaint against me. And this was about 3 months after the initial interaction, to my understanding. As I stated before in my IA, I did not remember running that plate. And when it came out with the hearing, there was a record that showed that the plate had been run. I had not run it on my computer or anything. I had dispatch had ran it. I hadn't had any interaction with this woman for several years prior to this, and I haven't had any interaction with her since this incident. I have no romantic inclinations with this woman, no desire to. I honestly do not feel that it was a BCI violation. I ran 16 plates that day. I don't recall all of them, but when I'm out working, I'm looking for registration violations, no insurances, following up with driver's license violations, reasons to find that vehicle so I can pull it over to make a legitimate stop. In this case, I do not believe I was in the wrong, and I am a person that will, if I do something wrong, I will take my lumps. Asking that the council will please issue me the letter of caution and be good with that. And I learned a lot from this lesson, and I apologize that I even have to stand before you. It's an embarrassment to me.
Any questions for Officer Bell? Anything further, Mr. Bell? Counsel?
Thank you. All right, just a couple things to point out before we have a motion on this. I want to point out a couple critical facts here. The first is that from the time of the incident to the time of reporting is about 3 months. The second thing I want to point out is, and most law enforcement officers here can attest to this, is that when you stop with a vehicle for even a consensual stop, it's standard practice to call up call it a license plate and vehicle description to dispatch. My client doesn't remember asking for a 28 or a vehicle check on that, but he does recall calling up a license plate. So just the time of space that elapsed here, 3 months, that information was not recorded, whether he asked for this or not, but he did give them a vehicle license plate description, which is standard practice. A letter of caution is appropriate here, and I'll give you a couple of comparable cases that kind of illustrate that. In 2018, we have Alexander Bell, and he accessed and disseminated warrant information to a CI about one of the CI's roommates. He also accessed his wife and father's driver's licenses. In 2017, Eric Zeman ran his own name and on his computer and received names of people that is related to, including his ex-sister-in-law. He received a letter of caution. And probably the case that I'm finding that's most similar to what we have today is in 2018, Travis Gerfin accessed 6 BCI records of himself and his daughter-in-law. Requesting VIN information. Just based on these other cases, I think a letter of caution is appropriate here. Are there any questions?
Make a motion.
I'd just like to address that.
Okay, go ahead. Ms. Beatty.
I know that Mr. Willey wasn't the attorney who conducted the hearing and wasn't present, but if I may just read very briefly one of the findings of fact into the record. So there was a hearing. The judge did hear Deputy Bell's testimony. He heard all the evidence in this case, and then he issued findings of fact and conclusions of law. One of the findings of fact that the judge issued in this case is that Bell did not observe the vehicle that he pulled over violate any law, traffic or otherwise, nor did he have any suspicion that the vehicle was stolen or otherwise involved in illegal activity. Bell had no law enforcement reason to stop or investigate the vehicle, its occupants, or its contents. That's why this is a BCI violation, because he had no reason to run the plate. It was a personal matter. Just to clarify that. This was totally personal, involved an owl. Any questions?
Victoria.
I do.
Yeah.
Marked unit?
He was in a marked unit.
In uniform?
In uniform, on duty.
But just, again, I understand that the issue is a BCI violation, but is it, I guess, counsel's position that this was a consensual encounter?
This was not a consensual encounter.
I mean, their counsel, just because you said consent, so. But marked unit, phone call to the occupant saying pull over so I can talk to you, that's consensual?
Correct. He was able to find a phone number from the rear of the vehicle because it was posted there. He called the driver, asked to speak to them. The driver pulled over.
Well, he's following the driver.
Correct. Indicating,
Please pull over so I can talk to you.
I don't have information for that conversation, but my client can speak to that.
I did contact her on her phone, and I asked her if she'd be willing to pull over and talk to me. I had prior interaction with her in the past where we had taken injured animals to her, and I just wanted to speak with her. Yes, she knew I was behind her, yes.
Further questions? Ms. Beatty, anything else?
I think that pretty much covers it.
Counsel? Let's go ahead. We have a motion.
I My motion is that we follow Post's recommendation and go with a letter of caution.
We have a motion from Chief Swanson to accept Post's recommendation. Do I have a second?
I'll second it.
I have a second from John Crowley. Any further discussion? Seeing none, we'll call for the vote. Those in favor?
Aye.
Any opposed? Seeing none, thank you.
The next case is Zan Elliott. Oh, there's almost no one here today. Oh, he is coming, okay. Zan Elliott, counsel for Zan Elliott? No, okay. The sustained allegations against Zan Elliott are domestic violence-related disorderly conduct at Class B and intoxication at Class C. The guidelines baseline are for a 1-year suspension. The range is 3 months to 2.5 years, and Post is recommending 2 years. The aggravators in this case is that there were multiple offenses and there were children present. There was a criminal case. He pled in abeyance to both charges, a Class B and a Class C, in January of 2019. There are no mitigators, and the alcohol was a primary factor in this case. He's unemployed. On June 17, 2018, Zan Elliott was investigated for domestic violence-related assault and intoxication. Elliott had taken his children and ex-wife camping the previous night. While at the campsite, Elliott and his wife drank excessively. Later in the evening, Elliott had an argument with his ex-wife. During the argument, Elliott's ex-wife claimed he pushed her, which caused her to fall and sustain a cut on her head from a flatbed trailer. Elliott told her he did not push her. One of Elliott's children heard the argument and exited the tent. Elliott's daughter told Elliott he needed to go to bed because he was drunk. Elliott slept in a tent, and Elliott's ex-wife slept in her vehicle. The following day, Elliott's ex-wife reported the incident to law enforcement. Elliott was contacted by law enforcement, investigated for the criminal allegations, arrested and booked into the county jail for domestic violence-related assault, 3 counts of domestic violence in the presence of a child and intoxication. On July 10, 2019, Post conducted a Garrity interview with Elliott. During the interview, Elliott denied pushing his ex-wife down or even seeing his ex-wife fall to the ground. He said his daughter did come out of the tent and told him to go to bed because he was drunk. On January 28, 2019, he entered a plea in abeyance to the charges of disorderly conduct with an attached domestic violence attribute and intoxication with an attached domestic violence attribute. He waived his right to a hearing. Any questions?
Do I understand Mr. Elliott is not here?
Mr. Elliott is not here, and his attorney is not here.
Any questions for Ms. Beatty? I have a question, Mike Haddon.
And it's not for Linda, sorry. If we were to approve the 2-year suspension, when would that time start running?
The date of separation?
But he
He was not employed.
Well, not employed, and it starts today.
Okay.
When the order is signed by
By the council.
A few days, actually, after following this. Ready for a motion? I've got a motion from Colonel Rappage to accept the recommendation of Post. Do I have a second? Got one from Sheriff Pulsifer. Any further discussion? Seeing none, I'll call for the vote. Those in favor?
Aye.
Any opposed? Thank you.
The next case is Robert Higdon. Mr. Higdon, or counsel for Mr. Higdon. He is coming, okay.
Ms. Vitti, we also have a letter in the file.
Okay.
A letter of support, if we could call Post Counsel's attention to that as well.
And I don't have that letter. Would you like me to get it and read it into the record?
Yeah, that would probably be the best.
Wait, maybe it's in the other file. I've got it now. Mr. Higdon, are you represented by counsel? Okay. Okay, this is the case of Robert Higdon. The sustained allegation is a BCI violation. He was employed by the Sunset Police Department for 22 years and continues to be employed by the Sunset Police Department, correct? The range is a letter of caution to 1.5 years. The baseline is 6 months, and Post is recommending a letter of caution. There are no aggravators, and the mitigator is he did not disseminate the information. Robert Higdon was investigated by his department for a BCI violation. The investigation disclosed that Higdon had accessed protected records to verify his current address, if his current address had been updated on he and his wife's driver's licenses. No criminal charges were screened. During a Garrity interview with the agency and Post, Higdon admitted to unlawfully accessing protected information. He said he'd been trained in proper use of USEGIS and knew that checking his address by accessing protected information was not permitted. He did not disseminate the information he accessed, and he waived his right to a hearing. There is a letter in the file from the Sunset Police Department dated November 21st, 2019. To whom it may concern, this letter is being written in support of Officer Robert Higdon. Officer Higdon has worked for the majority of his career in the Sunset City Police Department. He's been an excellent employee for the entire time he's worked here. I've been the chief of police for a large portion of his career, and I've had the opportunity to know him and work with him. On September 8th, 2019, he made a mistake, and he ran a curiosity check on his and his wife's driver's licenses. He immediately owned up to what he had done. He requested a meeting in my office happen soon so he could show that he was accepting and not trying to hide his mistake. He's been reprimanded by his office with a letter in the file. As the chief of police for this department, I believe that Officer Higdon has learned a lesson. I'm confident this will not happen again. I'm in support of a letter of caution, and I'm convinced this will not happen again. I can be reached for any questions or concerns. Or would you like to make any comments to the council?
Good morning, council. Thank goodness mine's not as involved. My frustration over something as simple as confirming my change of address led me to a complete lapse of judgment, one that I deeply regret. I have let my department my chief, and my coworkers down. Sincerely regret the mistake. I accept my responsibility for my actions and stand here before you today to accept whatever decision the council makes. I'm not the one to enjoy the center of attention, and quite honestly, this scares me, obviously. Very intimidating, and I can guarantee I won't stand here again. Thank you.
Any questions for Mr. Higdon? I have a motion from Chief Alan Swanson.
I would motion that we again follow Post recommendation with a letter of counsel.
We have a motion to accept Post recommendation. We have a second from Chief Soph. Any further discussion? Seeing none, we'll call for the vote. Those in favor? Aye. Any opposed? Thanks, Mr. Higdon. Thanks, sir.
Okay, the next case is Justin Jones. Mr. Jones, are you present, or is your attorney present? It appears that Mr. Jones is not present and no attorney is present for Mr. Jones. The sustained allegation against Justin Jones is driving under the influence. The range is 3 months to 2.5 years. The baseline is 1 year, and Post is recommending 18 months. Justin Jones has been a University of Utah police officer for 4 years, or had been a University of Utah police officer for 4 years. He resigned. One of the aggravators in this case was previous Post discipline. Why don't you explain that?
I just wanted to clarify, he had not been employed by the University of Utah for the full 4 years. He had experience from a previous agency until he was investigated by Post previously and sanctioned. When he came back from suspension, that's when he was employed by the University of Utah. What's that?
Was it investigated for the same type of incident?
It was.
Yeah.
Okay. All right. So he is no longer employed. So the aggravator is previous Post discipline, as you just heard. Alcohol was a primary factor in this case. There are no mitigators. On or about July 28, 2019, Justin Jones was investigated by a local police agency for driving under the influence of alcohol, the investigating officer determined Jones was impaired, arrested him for DUI. Jones submitted to a chemical breath test which measured his blood alcohol content at 0.089. A subsequent sample was obtained to verify the Baker time frame and ensure there was nothing in his mouth which could invalidate the test, and the subsequent sample measured at 0.073. Jones was charged with DUI and resigned his position before an internal administrative investigation could be completed. During a Garrity interview with Post, Jones admitted he was impaired, and he waived his right to a hearing. Any questions?
What was the outcome of the charges?
The criminal case is still pending. The pretrial was on September 30th, 2019. Do you know what the current date is? It's still pending.
And the prior one in 2017, was there a conviction for DUI?
I believe there was a conviction. I do not recall right offhand. I know that he came before the council in December of 2017. He received a 1-year suspension at that time.
Thank you.
We have a motion?
Make a substitute motion? Or
A substitute motion.
Not a substitute, I guess it'd be a motion?
A motion.
All right. Being the facts that in 2017 he was convicted of a DUI or brought before council, it's only 2 years later, he's up for another one. I recommend with category D, we go to the full extent, which looking at the matrix, it'd be a 2.5-year suspension. 2.5 years.
We have a motion for a 2.5-year suspension, category D.
Yeah.
I have a second from Colonel Rappage. Any further discussion? Seeing none, I'll call for the vote. Those in favor?
Aye.
Any opposed? Thank you.
Okay, the next case is Troy Ney. Mr. Ney, or an attorney representing Mr. Ney. Mr. Ney is not present. No attorney appears to be present for Mr. Ney. The sustained allegations against Troy Ney are willfully falsifies any information to obtain certification. The range is 9 months to 3.5 years. The baseline is 2 years, and Post is recommending 2 years. He was previously employed by the Utah Department of Corrections, but is not currently employed. He had 3 years of service with Department of Corrections. No aggravators, no mitigators. On March 22, 2019, Troy Ney was investigated by Post for willfully falsifying any information to obtain certification. The investigation disclosed that on March 25, 2006, Ney had been arrested for rape while in the military. Ney did not disclose the arrest on his Post application in 2015. Ney also documented no under the question, have you ever been part of a court-martial by a military tribunal or received military sanctions? Ney had received discipline from the military to include loss of rank and pay. No criminal charges were filed. On April 24, 2019, during a Garrity interview with Post, Ney admitted to being handcuffed and arrested for the crime of rape. Ney admitted to being disciplined by the military for his conduct. Ney stated he did not document the rape allegation in his Post application because he was not charged with rape. Ney said the military charged him with indecent acts instead of rape. Ney said he was not criminally charged but received military discipline. Ney admitted he did not document the military sanctions on his Post application. He failed to respond to a notice of agency action, and an order of default was entered against him. Any questions on this case?
We have a motion.
Just clarification, I don't believe I need to recuse myself in this case because he was not employed by our department.
Correct, if he wasn't
Do you have any
employed.
personal knowledge of this?
No.
Motion to accept.
I have a motion to accept from Colonel Rappage. Do we have a second? Second from Sheriff Curtis. Any further discussion? Seeing none, I'll call for the vote. Those in favor?
Aye.
Any opposed? Thank you.
Next case is Jared Palmer. I believe he's present, and his attorney. The sustained allegation against Jared Palmer is willfully falsifies any information to obtain certification. The range is 9 months to 3.5 years. The baseline is 2 years, and Post is recommending 2 years. There are no aggravators and there are no mitigators. Deputy Palmer is currently employed with the Grand County Sheriff's Office and has had 5.5 years of service. However, opioid use is a secondary factor in this case. On or about July 14th, 2013, Jared Palmer completed an application to attend post-training for corrections. Palmer did not disclose training or using prescription drugs illegally. On March 12th, 2019, Palmer completed a second application to attend post-training for law enforcement certification. In the second application, Palmer disclosed he was addicted to opioids and was purchasing and using prescription drugs illegally between the years 2006 and 2010. On March 28, 2019, in a post-Garrity interview, Palmer confirmed he had an opioid addiction between the years 2006 and 2010 and was purchasing and using prescription opioids illegally. Palmer stated he had notified the initial law enforcement agency during the hiring process. The agency was contacted and stated Palmer had not disclosed his illegal prescription drug information, either verbally or in writing. Had the information of the drug addiction and illegal prescription use been disclosed to Post, Palmer would not have been allowed to attend BCO training in 2013. On September 26, 2019, Jared Palmer waived his right to a hearing before an ALJ and stipulated to the facts in the notice of agency action. Mr. Palmer or Mr. Willey, would you like to address the council?
My name is Rich Willey, attorney for Jared Palmer. I'd like to give my client just a couple minutes to address the council, and then afterwards I'd like to take a couple minutes. Thank you.
Morning, ladies and gentlemen. I want to start by filled out that application. I didn't read it thoroughly. I was just misunderstood. At the time when I was taking hydrocodone without a prescription. I had recently had surgery on my shoulder. I was reading the application. I was looking for hydrocodone. Hydrocodone wasn't on that list. So therefore, I didn't think I had to put it. It was just a stupid mishap, you know. What I've learned is, you know, from my addiction, that is what drove me to get into law enforcement, especially corrections, because I thought maybe I could get in there and make a difference. I've been down that road. And you know, it's not a fun road. It took a lot of years of my life away. But you know, I finally found something that I enjoy. Found something that I think I'm good at. You know, Grand County still employs me, and I've been on paid administrative leave since March because they want me back. They want to see what the outcome is of this. And, you know, I've learned from my mistakes. I've learned to never sign anything without thoroughly reading it. And there's no such thing as a stupid question. I mean, I should have asked somebody about this. And, you know, like when I filled out my law enforcement application, I put it on there. Why I didn't on my corrections one, I honestly, I don't know. I think I just misread it. But I will admit that I did willfully, I did falsify a document, but I did not do it willfully. I did not do it with any intentions to deceive anybody. But I have learned from my mistakes. And sorry, excuse, I'm a little nervous up here. But like I said, law enforcement, I have finally found something that I enjoy. And I think I can make a difference. Because like I said, I've been down that road. And nothing good comes from being down that road. I just want to say thank you. And I'm very sorry that I even have to be up here in front of you guys. This, like Deputy Bell said, this is very embarrassing. Thank you.
Please, Ms. Beatty.
So this is not in the notice, but if I may respond to something raised by Deputy Palmer, I have the question that he was asked in his 2013 application. May I read out loud the question that he was asked in his 2013 application?
Yes, go ahead.
The question was, it was question 11, list and explain in detail any, in capital letters, and all, in capital letters, drugs you have used illegally throughout your life. Palmer responded with some illegal possession of tobacco and other things, but not the, that I won't mention here, but not the drug in question here.
Thank you. That was 2013?
Yes.
Thank you.
Thought I had put on there that in high school I had tried marijuana in crank.
Right, but
Well, I'm being honest. I'm sorry.
Thank you. Counsel?
Just a couple things. On question 11, it's in 3 parts, A, B, and C. Part B is exactly as Ms. Beatty described. Part C is where I think some of the confusion came out of, as it lists out a fairly extensive list of drugs, and hydrocodone is not listed on there. I believe that's part of the confusion. The bottom line here is that mistakes were made on this application, and I think that my client's work history and career will show that he's learned from it, and it's evidenced by the most recent application. The changes that occur in law enforcement can be substantial sometimes, and the person that filled out that application in 2013 and the person that appeared before you today are 2 very different people. And over the course of those 6 years, I think that he's grown in a lot of ways, and I think this experience is going to help him continue to grow. I want to just point out a couple of comparable cases that'll help guide the council when considering what amount of discipline is appropriate here. In September 2015, Austin Sheffer furnished alcohol to his 18-year-old girlfriend and did not disclose it on his post application. In December 2017, Bridget Whitman failed to properly disclose an expunged retail theft conviction on her post application. And that first one ended up in a 1-year suspension. She did not disclose that expunged conviction. She ended up with a 9-month suspension. And probably the case that's most similar to what we've got today is in September 2015. Joseph Coate submitted an SFO and BCO post application where he did not disclose drug use, but he admitted to drug use during the hiring process. In the investigation, my client claims to have reported that to his sergeant during the hiring process, and so the similarities to those 2 cases are closest. In that case, post deviated downward from a 2-year suspension to a 9-month suspension. So in this case, we would ask that post similarly deviate downward to 9 months on a suspension. Are there any questions?
Ms. Beatty?
I'd point out just 2 more facts. One is that Deputy Palmer insisted that he did report this information, first of all. And secondly, when he was interviewed, and secondly, we're talking about an addiction, not a one-time use. So the facts are a little bit different here. That's all I have.
Chief Silv.
So had he reported that to post in 2013, what would have been the extension until he could reapply? How long would it be?
The date of last
usage. So is it set though 1 year, 2 year, or is there a depend on the drug?
So it depends on the drug. If it was equivalent to a felony, it'd be a 4-year wait. Marijuana is typically a 2-year wait back then. So yeah, there were some waiting periods based upon the type of drug.
Would that include current prescription drug, or how would that work?
Yes, under how it's scheduled. Yes.
I know I had an officer that I was going to hire that had used one time Ambien from somebody else at college, and he had to wait a year before I could hire him and put him through post.
Because of the schedule.
Okay. Director Haddon.
Yeah, I'm not sure if I can ask this question or not, but I'll give it a shot. So my understanding of reading the case was he was accessing hydrocodone without a prescription. Is that correct? Yes. Can we find out how he was accessing the drug without a prescription?
Or just ask him if he didn't think that that was illegal, since you didn't have a prescription. You didn't or did? I knew. You knew.
Can you come to the podium?
I knew it was illegal, but I had a problem.
So you tried to hide it purposely, obviously.
Yes.
Because you knew that that's something you should divulge to Post, correct?
Well, at the time when I filled out the application, I was thinking, because there's a list of a bunch of different drugs, and hydrocodone's not on that list. Central nervous system depressants is, and at the time I didn't know that's what hydrocodone was.
But any prescription you're getting without a legal prescription from a doctor would be an illegal act.
Yes.
And you knew that?
I know that now.
You didn't know that then?
Well, I knew it was illegal.
Okay. Okay,
But I figured since it's not on that list, I shouldn't have to put it.
So can I ask how you were able to get the medication?
A buddy of mine, he was getting some, and I was buying them from him.
Any further questions?
I would add that the application does ask the applicant to disclose any criminal acts. If someone knows something's illegal, that would make it a criminal act. And that's, so that is act. That's on the act.
That's where I screwed up. I just didn't read it thoroughly.
Do we have a motion?
Motion to accept.
We have a motion from Colonel Rappich to accept. Do we have a second?
Second.
Second from Spence Austin. Any further discussion? Seeing none, I'll call for a motion. Those in favor?
Aye.
Any opposed? Thank you.
Just one more thing. Is
Please,
that dated from his ejection from Post?
From his, he's on paid administrative leave, correct? Is that correct? Right now? So it'll be from when the order is signed, which will probably be within a couple of days.
Yes, sir.
Thank you.
So am I correct that there are no other respondent officers, no other officers present or attorneys from here on in, and we're on case number 7 of 16? Okay. The next case is Holman-Penna. The sustained allegation is a willful falsification of application to obtain certification in line under Garrity. The range is 3 years to revocation. Post recommends revocation. The baseline is revocation. There are no aggravators, no mitigators. He was a previous UHP cadet, but he didn't work as a trooper. He wasn't actually employed. On August 7th, 2019, Holman-Penna was investigated by Post for willful falsification of application to obtain certification. Pena was charged with trespassing as a juvenile and did not document that crime in his Post application. Is it Pena or Pena? Pena. Was also documented 2 traffic citations on his Post application and 1 traffic citation on his addendum. Investigators located an additional 8 traffic violations in which he paid a fine that Pena did not document on his Post application. Post verified with Pena's employing agency's background investigator that the traffic citations were discussed with Pena prior to Pena completing his Post application. On August 7, 2019, during the Garrity interview with Post, Pena admitted to being charged with trespassing and told investigators that he still had the citation he was given. When asked why he did not document the trespass charge, he responded, "I probably misread the question." The question was, have you had any other arrests, criminal involvement, or convictions not previously identified, both as a juvenile and an adult? After reviewing his Post application and his addendum with Pena to include the criminal charges with traffic citations that he documented in his Post application, Post asked Pena, "Is there anything else that you haven't put on your application or that you can remember not putting on your application?" He responded, "No. We have the tickets, the arrest, and the trespassing." Post clarified that that a citation was considered an arrest, and asked him if there was anything else that he'd been convicted for, arrested for, or involved in that he did not document on his Post application. He again stated he had documented everything. Post was aware of the 8 traffic citations that Pena had not documented in his Post application prior to the Garrity interview, and gave him multiple opportunities to disclose the traffic violations that he had not yet disclosed. Pena never disclosed the 8 traffic citations during the Garrity interview with Post. And this case resulted in an order of default. Any questions?
What's that? Oh, we have to show that Colonel Rappage has to recuse himself. Any questions? Have a motion to accept from Sheriff Pulsifer. Second from Director Haddon. Any further discussion? Seeing none, I'll call for the vote. Those in favor?
Aye.
Any opposed? Thank you.
The next case is Colleton Roseborough. The sustained allegation is lying under Garrity. The range is 3 years to revocation. The baseline is revocation, and Post recommends revocation. There are no aggravators or mitigators. He was employed by Chihuahua City for 2 years, and after administrative leave, he resigned in lieu of termination. On January 14, 2019, Colleton Roseborough was investigated for an allegation of having an affair and sexual conduct on duty. 2 Department Garrity interviews were conducted with Roseborough. During the Department Garrity interviews, Roseborough denied having any sexual relationship with the female. Roseborough stated he kissed the female on 2 separate occasions, but that was the extent of their relationship. The female was contacted by his department, and she admitted to having sex with Roseborough on at least 2 occasions. The female said one of the times she had sex with him, he arrived at her residence in his patrol vehicle and in uniform. On March 12, 2019, during a Garrity interview with Post, Roseborough denied doing anything on duty, denied having a sexual relationship with the female. The Post investigation could not prove he engaged in sexual conduct on duty. However, investigators had to ask questions regarding his personal life to determine if the sexual conduct was on or off duty. Therefore, there's a nexus to the original complaint of sexual conduct on duty. Post was able to obtain several text messages and marriage counseling notes that verified that there was an affair between Roseborough and the female, and that something more than kissing had occurred. Therefore, even though Post was unable to sustain the sexual conduct on duty allegation, Post did sustain several Garrity violations throughout the investigation. And this case resulted in a default order being entered. Any questions?
Able to sustain the sex on duty allegations, because the way I read it, you have kind of a witness, don't you, to that being wife B?
Yeah. Yeah. So the I don't know how to say it. The wife of the other half of the party said yes, they had sex on duty, but where Roseborough denied it. The only I couldn't verify that they had sex on duty. However, the text messages and marriage counseling notes that I was able to obtain showed that there was an affair. Whether or not it was on duty or not, I couldn't sustain that. Does that make sense? And what it really comes down to is Roseborough said that he had only kissed this girl twice, and that was the extent of their.
Tattoo, though, right?
What's that?
She saw the tattoo, though, right? Yeah.
She saw a tattoo, and that was another area of concern in my Garrity interview. Roseborough claimed it was on his Facebook page, and so anyone could see that tattoo. When I checked, it wasn't right after that Garrity interview, but it was after the Garrity interview. When I checked, there was no picture of him in a bathing suit showing that tattoo or anything like that. So there were different areas in this investigation that I just wasn't able to come to a conclusion on.
Make a motion to accept the Post recommendation for revocation.
Chief Silk makes a recommendation to accept Post's recommendation for revocation. I have a second from, who's the second from Chief Swanson? Any further discussion? Seeing none, we'll call for the vote. Those in favor?
Aye.
Any opposed? Thank you.
Okay, the next case is Aaron Rosen. The sustained allegation is sexual misconduct with a 16 or 17-year-old. The range is 3 years to revocation. Baseline is revocation. His post is recommending revocation. Mr. Rosen was employed for 20 years and is no longer employed. He retired, but he still has an active certification. There was a criminal case, a jury trial, and he was found guilty on both counts. The court dismissed with prejudice the Class A misdemeanor. He served 120 days in jail and 3 years probation, or 120 days in jail, and is apparently still on probation. The aggravator in this case is that there are multiple charges. On July 27, 2017, Aaron Rosen went to the home of a 16-year-old juvenile he met on a social media dating app. Rosen and the juvenile engaged in sexual acts that constitute unlawful sexual misconduct with a 16 or 17-year-old. Rosen was interviewed the same day and admitted the two of them laid on the couch, well clothed, started kissing. He admitted he was grinding his penis against the juvenile, stroked the juvenile's penis and inner thigh area with his hand, but stated he did not know the juvenile was 16. Rosen was booked into jail. During the preliminary and criminal trial, the juvenile testified oral sex occurred between Rosen and himself. On May 3rd, July 2019, at the conclusion of the jury trial, Rosen was found guilty of 1 third-degree felony and 1 Class A misdemeanor of unlawful sexual misconduct with a 16 or 17-year-old. The court dismissed the Class A misdemeanor with prejudice. This case was resolved by an order of default. That's it.
Have we had Mr. Rosen before us prior? Post counsel? Maybe I'm wrong.
It didn't come before the council,
Okay.
but we had it.
All right.
Received a complaint.
All right, thank you. I thought we had for some reason.
That we accept, and then we don't have to see it there again.
Okay, we have a motion from Chief Swanson to accept post recommendation for revocation. Second for John Crowley. Any further discussion? Seeing none, we'll call for the vote. Those in favor? Aye. Any opposed? Thank you.
The next case is Wyatt Shapiro. The sustained allegation is child abuse, intoxication, and disorderly conduct. The range is 9 months to 3.5 years. The baseline is 2 years, and post is recommending 3 years. Wyatt Shapiro was employed by the Davis County Sheriff's Office for less than a year. He's no longer employed by the Davis County Sheriff's Office. The aggravator in this case is that there were multiple charges. In the criminal case, he entered a plea, which was amended to disorderly intoxication. Entered a plea deal which amended child abuse to disorderly, and the intoxication was dismissed with prejudice. Alcohol was a primary factor in this case. On December 23, 2018, Wyatt Shapiro was investigated by a local police agency for child abuse and intoxication. The investigation disclosed that Shapiro vomited on the floor in the front room. Shapiro picked up a towel his wife had been using to clean up his vomit and threw it at her. A verbal argument then ensued between Shapiro and his 17-year-old stepdaughter over how he was treating her mother. Shapiro stood, fists clenched, and closed the distance between him and his stepdaughter. He then punched her in the right shoulder, causing her to fall backwards onto a couch. He was booked into jail on intoxication and child abuse. He was placed on administrative leave and was terminated from employment in January 2019. He admitted during his post-interview that he drank 3 or 4 beers while working in the basement and then waking up in jail. He said he did not remember anything else and doesn't know why he blacked out. This case also resulted in a default order being entered.
Any questions for Ms. Beatty? Seeing none, we'll call for a motion. Motion from Sheriff Curtis to accept post recommendation. Is that correct?
That's correct.
And a second. Chief Silv has a second. Any further discussion? Seeing none. Those in favor? Aye. Any opposed? Thank you.
The next case is Michael Straub. The sustained allegation is assault. The range is 9 months to 3.5 years. The baseline is 2 years, and post is recommending 2-year suspension. He is currently unemployed, was previously employed with the Washington County Sheriff's Office. He has 6 months service time. Alcohol is a primary factor in this case. There are no aggravators and no mitigators. The criminal case, which was a charge of battery, was dropped. On May 16, 2019, Michael Straub was investigated by a police department in Florida for battery. The investigation disclosed that on May 16, 2019, Straub was involved in a physical altercation in a pub. An off-duty police officer observed Straub push a security guard and then attempt to punch the security guard. Straub was arrested by the officer. On May 17, 2019, Straub was charged with battery, which is a misdemeanor, first-degree misdemeanor, and the charge of battery was dropped on the same day. On June 24, 2019, Straub spoke with a post investigator via telephone. He said he was involved in a physical fight in a bar in Florida. He requested a voluntary relinquishment form, which was emailed to him. Straub said it would save Post from doing an investigation on him for being a drunk asshole in a bar. However, Straub never submitted the voluntary relinquishment form and did not participate in the Post investigation. And once again, an order of default was entered against Mr. Straub.
Any questions for Ms. Vitti? We have a motion from Sheriff Pulsifer. Sheriff Pulsifer needs to recuse himself. He's the Sheriff of Washington County.
I'll motion to accept.
I have a motion to accept from Chief Swanson. Second from Director Haddon. Any further discussion? Seeing none, we'll call for the vote. Those in favor? Aye. Any opposed? Thank you.
Next case is Jose Suarez. Yeah, no one's here. The sustained allegations are failure to stop at the command of law enforcement, escape from custody, DUI, reckless driving, resisting arrest, accident involving property damage. The range is 3 years to revocation, the baseline is revocation, and Post is recommending revocation. The aggravators in this case are that there are multiple charges. There are no mitigators. In the criminal case, he pled guilty to amended failure to stop, which is a third-degree felony. Pled guilty to amended failure to stop, which dropped it from a third-degree felony to an A misdemeanor, and driving under the influence. Escape from custody, reckless driving, resisting arrest, accident involving property damage were dismissed with prejudice. He had 1 year of service. He's currently unemployed. On May 26, 2018, Jose Suarez was observed driving recklessly by a local agency. An officer attempted to stop Suarez, who sped off at over 100 miles per hour, hit a traffic sign, and rolled his vehicle at the bottom of an off-ramp. Suarez fled the scene on foot, but was located and taken into custody. After being placed in handcuffs, Suarez ran away and was recaptured. After exhibiting multiple clues of impairment, a blood sample was obtained from Suarez, which measured 0.12 blood alcohol content. On April 23, 2019, Suarez was convicted of failing to stop at the command of law enforcement, which was amended from a third-degree felony to a Class A misdemeanor, and for DUI, a Class B misdemeanor. The other 4 charges were dismissed with prejudice. Suarez did not participate in the Post investigation, and an order of default was entered against him.
Any questions?
Was he employed at the time of this
Was he
case?
employed at the time? Where was he employed? Doesn't say.
Oh, he was unemployed.
Motion to accept Post recommendation.
John Crowley has a motion to accept Post recommendation. Second from Sheriff Pulsifer. Any further discussion? Seeing none, I'll call for the vote. Those in favor? Aye. Any opposed? Thank you.
Next is Jennifer Swenson. The sustained allegation is DUI, willful falsification of application to obtain certification. The range is 9 months to 3.5 years. The baseline is 2 years, and Post recommends 3 years. Jennifer Swenson was employed for 15 years with the Orem Police Department Dispatch, but has been terminated. The aggravators are multiple offenses. There are no mitigators. In the criminal case, she pled no contest to impaired driving, a Class B misdemeanor. On January 5th, 2019, Jennifer Swenson was investigated for DUI by a local police agency. The investigation disclosed Swenson had taken Ambien and Xanax earlier in the day and operated a motor vehicle. Swenson was arrested for DUI and submitted to urine and blood tests. The urine test showed positive for benzos. Say that? Yeah.
Benzos.
Yes, benzos. Got it.
More commonly known as.
On May 6, 2019, Swenson entered a plea of no contest to impaired driving, a Class B misdemeanor. She was terminated from her agency in February 2019. Post-investigation determined Swenson failed to disclose a domestic violence-related criminal trespass of a dwelling and intoxication incident on her post-application, which was completed on October 9, 2015. She did not participate in the investigation, and an order of default was entered against her. Any questions?
Make a motion to accept the 3-year suspension recommended by post.
We have a motion from Chief Self to accept the 3-year suspension. The second is Colonel Rappage. Any further discussion? That will go ahead and call for the vote. Those in favor?
Aye.
Aye. Any opposed? Thank you.
Dusty? No, there's no one here. There are no officers. Yeah, or attorneys, right? The next case is Richard Vale. The sustained allegations are driving under the influence of alcohol, failure to stop or respond at the command of police, carrying a dangerous weapon under the influence of alcohol, and failing to remain at the scene of an accident. The range is 3 years to revocation. The baseline is revocation, and post is recommending revocation. Richard Vale was employed by the Carbon County Sheriff's Office for 1.5 years. He was terminated. The aggravators in this case are multiple offenses and a past pattern of conduct, criminal history convictions. He pled guilty to DUI, failure to stop at the command of an officer, and failure to remain at the scene of an accident. I'm sorry, that's not correct. He pled guilty to DUI, failure to stop at the command of an officer, and failure to remain at the scene of an accident were dismissed with prejudice. On October 7, 2018, Richard Vale, a certified police officer, was investigated by a police agency for driving under the influence of alcohol, disorderly conduct, failure to stop or respond at the command of the police, carrying a dangerous weapon under the influence of alcohol, and failing to remain at the scene of an accident. He was transported to jail and booked on those charges. On February 22, 2019, the county attorney's office filed the charges of driving under the influence of alcohol or drugs, a Class B misdemeanor, failing to stop or respond to at the command of police, and a third-degree felony, and failure to remain at the scene of an accident with damage, a Class C misdemeanor. On June 3rd, 2019, he entered a plea deal to the DUI. The charges for failing to stop or respond at the command of police and failure to remain at the scene were dismissed with prejudice. He was terminated in November 2018, and he has not responded to any attempts to contact him. An order of default was entered against him. Any questions?
Not that it matters, but I'm just curious, was it his own agency that he was running from?
I don't know.
I make a motion to accept.
Is that a motion to accept? Okay. Chief Swanson, do we have any other comments here?
I have a question.
Okay, Director Haddon, please.
Also probably doesn't make a difference, but did you say that he had previous discipline?
Yeah.
Before he became an officer, he had criminal discipline.
Why was he?
What?
Thank you.
So we currently have a motion from Chief Swanson to accept post recommendation. Do we have a second from Director Haddon? Those in favor? Aye. Any opposed? Seeing none, thank you.
Next case is Austin Van Eckelenberg. Eckelenberg? Okay. The sustained allegation is possession or use of a controlled substance, specifically steroids, and lying under Garrity. The range is 3 years to revocation. The baseline is revocation, and post is recommending revocation. He was employed by the Tooele County Sheriff's Office, but he was terminated. The aggravators are that there are multiple charges, there are no mitigators, and he has no years of service. On October 10th, 2018, Van Eckelenberg was investigated by his agency for steroid use and lying under Garrity. He was attending the police academy when he told a coworker that had been using steroids. During the Garrity interview with his agency, he denied using steroids. He submitted a urine chemical test, and the result was positive for steroids. He was terminated in October 2018. In August 2019, during a Garrity interview with Post, he admitted he used steroids approximately 10 days prior to starting the police academy and admitted to lying to his agency after being advised of his Garrity warnings. An order of default was entered in this case also. Any questions?
Seeing none, I'll go ahead and call for a motion.
Motion to accept.
Motion to accept from Colonel Rappage. Second from Sheriff Curtis. Any further discussion? Seeing none, I'll call for the vote. Those in favor? Aye. Any opposed? Thank you.
And the last case is Shane Visser. The sustained allegations are possession of a firearm by a restricted person in violation of a protective order. The range is 3 years to revocation. The baseline is revocation, and Post is recommending revocation. The aggravators are a previous post case, and multiple offenses. There are no mitigators. He is unemployed. In the criminal case, he pled guilty to an amended charge of possession of a firearm by a restricted person. By restricted person, is that what we're trying to say? Mm-hmm. Okay. A Class A misdemeanor in violation of a protective order with an attached domestic violence attribute, a Class A misdemeanor. In November 2018, Visser was investigated by a local agency for possessing a firearm while being a restricted person due to an active protective order. The protective order was issued after Visser made threats to kill his estranged wife and 2 4-year-old sons. The local agency learned that Visser met with his brother at Visser's storage unit. While at the storage unit, Visser opened a gun safe, took out a Glock handgun, and placed it in his waistband. He then left the storage unit with the handgun in his possession. Visser's brother knew Visser was not allowed to possess a firearm due to the protective order and the reasoning for the protective order. Visser's brother reported the incident to the local agency, who conducted a criminal investigation. Charges were filed on Visser with the district attorney's office for possession of a firearm by a restricted person, a third-degree felony, and a violation of a protective order, a Class A misdemeanor. On April 1st, 2019, Visser pled guilty to an amended charge of possession of a firearm by a restricted person, a Class A misdemeanor, and a violation of a protective order with an attached domestic violence attribute, a Class A misdemeanor. He did not participate in the post-investigation. And it should be noted that on March 19th, 2019, Visser was the subject of a case presented to Post Counsel. The allegations against Visser were driving under the influence of alcohol and intoxication. Post Counsel subsequently suspended Visser's peace officer certification for a period of 2.5 years. His suspension will conclude on September 19th, 2021. And he did not respond to the notice of agency action. An order of default was entered in this case.
Director Haddon.
I'd move to accept the Post-Counsel's post recommendation.
We have a motion from Director Haddon to accept the post recommendation for revocation.
Second.
Second from Sheriff Pulsifer. Any further discussion? Seeing none, I'll call for the vote. Those in favor?
Aye.
Any opposed? Thank you.